everybody, welcome to Learn with Steph. This is one of the videos as part of our Lessons in Law series. The focus is on OCR A Level Law, but it will be useful to anybody studying law. If you like the videos, please do subscribe and press the like button at the bottom. This is our third lesson on liability and negligence. In the first two lessons, we went through duty of care and breach of duty. So just to remember, negligence is made up of three elements: duty of care, breach and resulting damages. Today's lesson is on resulting damages. Remember, this is different from compensatory damages, which appears as part of our remedies section. So resulting damages can be divided into two: causation and remoteness. We're going to start with looking at causation. So was the damage caused by the breach? So first of all, causation. So in civil law, it's similar to criminal law. So you need to be very careful that you don't confuse the cases you've learned for criminal law with this negligent civil law causation. So for causation on resulting damages, we're looking at the but-for test. The case would be Barnett versus Chelsea and Kensington Hospital. And in this case, a man went to the A&E department. He didn't feel very well. He had been vomiting. And basically, he was sent home and told to see his GP. The hospital didn't see him at all, in fact. He actually died later that day of arsenic poisoning. In this case, the hospital were held not to be liable due to the but-for test here, because the man died of arsenic poisoning, and even if he had seen the A&E doctor, he would have died. The doctor would not have been able to save him. So but for the breach, because there was a breach, the doctor didn't see him, so but for the breach, he would have died anyway. So the damage was not caused by their breach. The second test is a little bit more complicated than the but-for test, and this concept is known as remoteness. And the question is, was the damage too remote from the breach? In other words, was the damage reasonably foreseeable? So only losses that are reasonably foreseeable can be recovered by a claimant. And that's what remoteness means. Was the damage a reasonable foreseeable consequence of the breach? Basically, some outcomes are so unlikely that nobody could have predicted them, and therefore a claimant won't succeed in their liability claim. Okay, so the consequence of the breach must be likely, must be foreseeable. The leading case of this comes from Australia, and it's the Wagaman case. And you may well remember having this case mentioned to you when you've been studying things like judicial precedent and persuasive precedent, because Wagaman was a case that was heard in the judicial the judicial section of the Privy Council, but it has become leading precedent in UK law. So Wagaman. And in this Wagaman case, oil spilled from a ship into Sydney Harbour. And basically, due to the trying to mend the ship, the oil was set alight. And it was held that the oil spill from the leak in the boat, that was a foreseeable consequence. But the fire actually wasn't a foreseeable consequence from the leak in the boat, and that was the breach. So the breach, it was too unlikely for the fire to happen from the breach, but the oil spill was a likely consequence. So the point of law is, for remoteness, it's got to be a foreseeable consequence, otherwise the negligence liability will fail. And it's the type of injury or the type of harm or damage that must be reasonably foreseeable. It doesn't matter whether the sequence of events isn't foreseeable or the exact manner of the harm isn't foreseeable. If the type of damage is foreseeable, that's the important thing. So for instance, if I fell down the stairs, there'd be a whole range of types of damages that would be foreseeable. Broken leg, broken neck possibly, dirtied clothes, twisted ankle, all of those damages would be a foreseeable consequence, possibly broken glasses. But the sort of damages that might not be foreseeable might be a broken window at the bottom of the stairs, perhaps, or perhaps a broken belt, possibly your heels coming off on a shoe. They might not be foreseeable damages. Those sort of damages might be seen as too remote. And Hughes v. Lord Advocate clarified the Wagaman ruling. In this case, workmen left a manhole open and they covered the hole with a tent and they put paraffin lamps around it. Now, paraffin lamps are highly flammable, and Hughes was a child and he was playing in the area. Now, you can imagine a paraffin light could cause a burn. So that is a foreseeable injury that could be caused by leaving paraffin lamps around where a child is playing. However, Hughes wasn't burned by the paraffin lamp. What happened was he knocked one of the paraffin lamps into the manhole and that caused an explosion, and he was burned from the explosion. Well, the ruling was that it was foreseeable that a child might be burned by lamps. Therefore, there's liability, because it doesn't matter if the precise sequence of events were unforeseeable. If harm itself is foreseeable, but it occurs in an unforeseeable way, there may still be liability, as illustrated in Hughes. And then finally, the precise extent of the injuries don't have to be foreseeable either. And this relates to what we might call the thin skull rule, in that you must take your victim as you find them. And in Smith v. Leachbrain and Company, a workman was pouring molten metal into a mould, and the metal splashed up and burned him on the lips. Now, the burn itself was very minor, and you can imagine a burn is a foreseeable consequence of pouring molten metal into a mould. So if he didn't have any sort of protection, that would be a breach, wouldn't it? So the burn was minor, but unfortunately it sparked dormant cancer, and that cancer killed him. So he died from the cancer, and the cancer was caused by the burn. The employer was still liable for negligence because the victim had to be taken as he was found, and that included having dormant cancer. Now, sometimes there might be events that break the chain of causation, and these would be called intervening acts. So for instance, in the case McHugh versus Holland, this gentleman got injured in a work accident, and it left his legs quite weak, and it meant they sometimes gave way. Unfortunately, he was climbing stairs and he didn't hold onto the rail as he was climbing them, and he fell down, and this caused further injuries. And it was held that the fact that he didn't hold onto the rail, his act broke the chain of causation. So his work could be liable for the original injury to the legs, but it couldn't be liable for the further injuries that were caused when he fell down the stairs. Let's have a look at a scenario now where we're going to bring all three elements, duty of care, breach of duty, and damages together, and even remedies and defences. So Ahmed had just passed his driving test and purchased a new car. He offered to take his neighbour, Bina, to the supermarket. Bina usually gets the bus and is not used to travelling by car. She refuses to wear her seatbelt as she says she feels trapped when wearing it. When leaving the supermarket, Ahmed puts the car in reverse gear by mistake. Consequently, he smashes the car into the wall behind him. Bina suffers a whiplash, neck injury, and has to take 6 weeks off work. She is also left suffering from an anxiety disorder and is now afraid to go outdoors. She wishes to sue Ahmed for negligence. And this is a 25-mark question, the sort of question that you would get on the OCR Section B part of the paper. And the question is, advise Bina whether Ahmed is liable to her in negligence, and if so, what remedies she might expect. With these sorts of questions, the first thing I would advise you to do is to identify who the defendant is and who the claimant is. And if you do this, it might prevent you making some silly mistakes later on, particularly with regard to characteristics that the defendant and the claimant have. So once you've identified the claimant and the defendant, you need to check to see whether the claimant and defendant have a duty. And you would ask yourselves, first of all, is this an obvious duty of care? Or is this a duty of care that will need to be assessed using the Capara rules? And you need to identify the breach. So has the defendant done something that a reasonable man wouldn't do, or not done something that a reasonable person would do? So you need to identify what that breach is. Then, of course, you need to think about the reasonable man test for breach. So are there any characteristics that are relevant to the defendant? So age and expertise are the only characteristics. But if a scenario mentions the person is inexperienced or a learner, that's not a relevant characteristic, but you would want to include that in your essay as part of a legal argument and mention Nettleship v. Weston says it's not a relevant characteristic. Then you would look at the risk factors. You would ask yourself, is the claimant particularly vulnerable? Is the probability of risk high? Is there some sort of social benefit in the activity being undertaken? What would be the cost and practicality of taking precautions? And sometimes you might find that none of the risk factors would have made a difference as to the standard of care that's expected. And I think that's probably the case in this scenario. Then you'd look at remedies. So for negligence, it's likely to be damages. So you need to identify what special damages, remember they're specific sums of money that are lost, or specific quantifiable losses, okay? Or are there general damages? So that's damages for pain, suffering, loss of immunity, and loss of future earnings. So identify those two types of damages. And then finally, does the defendant have any defence that might be relevant? You're looking at valenti and you're looking at contributory negligence. And these are the sorts of highlights that you would make, perhaps. So you've identified that Ahmed is the defendant and the claimant is Bina. You've identified that there is a duty because Ahmed owes a duty of care to anyone that's in his car and anyone that's on the road, and that's an obvious duty of care. So in your scenario question, you would state it's a statutory duty of care. But you could also apply the Kapara rules as well. Clearly there's proximity because they're in the car at the same time. The fact that she's his neighbour wouldn't be relevant in regards to duty of care here. It's the fact that she's in his car at the same time and he's driving. It is reasonably foreseeable if somebody backs into a wall, it might cause the passenger damage. And there's no policy reason why the court would not award a duty of care in this circumstance. It wouldn't open the floodgates of litigation. It wouldn't be to detriment of society. It would benefit society to make a driver have a duty of care to his passengers. So you could state that it's a statutory duty, but the Kapara rules also work. Okay, so the breach is when Ahmed puts the car in reverse and then smashes into the wall behind him. That's what he does wrong, if you like. That a reasonable, competent driver would not put a car in reverse and smash into the wall behind him. So he's done something that a reasonable person, reasonably competent driver wouldn't do. So does the defendant have any relevant characteristics? Well, again, age isn't an issue here. Expertise isn't an issue here. However, the scenario does say that he's just passed his driving test. So as I said before, you would want to mention that he's inexperienced. However, this is not a relevant characteristic as illustrated in Nettleship v Western. Relevant characteristics, probably not. No risk factor, sorry, here is going to affect the standard of care. Remedies, well, we've got general damages here with the whiplash neck injuries and anxiety disorder, sorry. So that's pain and suffering, possibly lack of immunity that might be compensated for. And then for special damages, we're told that she has to have 6 weeks off work. So it's likely that she would have a claim for that. And then the defences. Now, this is where the seatbelt comes into play. And a really common mistake on this question is candidates might write that there is no breach because she should have been wearing a seatbelt. And yes, she should have been wearing a seatbelt, but there is still a breach. So the fact that she refuses to wear her seatbelt comes into defences, and it comes into contributory damages, contributory negligence, sorry. She has contributed to the damage, and therefore the court will take that into account when they're awarding any damages. So that's where the refusing to wear the seatbelt comes in. So we've now looked at all the elements required for liability and negligence. Duty of care, breach of duty, and damages, resulting damages, regarding causation, the but-for test, and remoteness, the test laid down in Wagaman. The fourth lesson in this series, the evaluation, is going to be uploaded later on after we've looked at all of the torts. That brings us to the end of this lesson in law. I hope you enjoyed it. If you did, please like it and subscribe to find more videos. Bye.